Welcome to Tarun IS. Today we'll be discussing an important editorial that appeared in the Hindu, and it is related with the overcrowding in prison. You can relate this topic with your general studies paper 2, that is government policies and intervention for the development in various sectors and issues arising out of their design and implementation. The title of the report that was published in the newspaper The Hindu is Indian prisoners are stretched to their limits. The report basically consisted of the data and facts pointing towards the condition of the prison, which are overcrowded, they are understaffed and unhygienic. Right. So now let's see the reforms which are required in the prison, why the reforms are required, and what committee gave what recommendation in order to bring about the reform in the country. And we will discuss one more interesting topic in this editorial, which is the concept of the open prison. Now let's see the context in which this report appeared. Basically, the BSF personnel who found that the illegal immigrants from the Bangladesh who had clean record were handed over to the Bangladeshis officials, and this brought to the light the age-old problem of the overcrowded prisons in India, and especially when it comes to the under trial prisoners. Now the data according to the article, it shows that over 5.54 lakh people were locked in prison, while the total capacity of Indian jails is about 4.25 lakh. So you can see the people who have been lodged in the prison and the capacity of the Indian prison. So that means the occupancy rate of the Indian prison is very high, which is approximately 130%, a peak at least in the last decade. Now, why do we require prison reforms? Now, basically, in order to uphold the fundamental rights of a citizen, of an individual, the principle of natural justice and the natural laws, a person, even though a criminal, requires a proper infrastructure. Now this infrastructure is not limited only to the physical infrastructure. However, a prisoner is also entitled to the food, to the proper hygienic condition, and a proper trial. And that is the reason why the condition of the under trial and this important issue of under trial prisoners in the Indian prison has been brought to the light. Now let's see the status of the Indian prisons and why do we require the prison reforms. The first point is that the overcrowding. We already saw that there is occupancy rate of 130%. So there is overcrowding. They are underfunded. If they are underfunded, that means their infrastructure will be low. The other facilities, for example, the health facilities, the tele-law facility, etc., and the norms and guidelines for the visitors, they all need to be reformed. When we speak of the health aspect of a person, we not only speak of the physical health, but we also speak of the mental health of a person. So therefore, the mental health of a prisoner is also important, because if we want to reform a society, all those people who have been lodged in the prisoner do require not the punitive justice, but the reformative justice too. And in this context only that we are going to discuss the open prison. But first, let us complete the prison reforms. They are understaffed. That means the lawyers, the police officials, and other staffs which are required for the maintenance of the prison is below the world average. There are cases of violent clashes between the prisoner and the authorities, and there are also cases where the inmates kill themselves after the violent clashes. There is lack of hygiene, the basic amenities, and they are deprived of a dignified life, which according to the Constitution of India is given to all citizens of India. So dignified life according to Article 21. And there is also a violation of Article 22, that is the proper trial. Now let's see the prison statistics in India. According to the report Prison Statistics in India, more than half of the prisoners were detained for less than 6 months. The overcrowding in the prison are due to the result of unnecessary arrest, increase in the number of people under preventive detention. There is unawareness about the section 436A of the CRPC. Now let's see what this section says. Now section it talks about that the police not to effect unnecessary arrest. Now these are the recommendations that the Supreme Court gave. But before that, we will be talking about this section. That what does this section says? This section actually talks about the bail to under trial. This section, the 436A, it talks about the bail to under trial. Now, when can the bail be granted? The important point here is that the bail to under trial to all those under trials who have served half the jail term for the offense. Right? That means that if a person has been lodged in jail for a certain crime and it is the under trial, that means the trial has not been completed in the court, and if this person has served half the term of imprisonment that was to be awarded if he or she was convicted of the crime that he or she was accused of. So this section provides for the bail under certain conditions. So unawareness regarding this section of the CRPC, lack of mental health, welfare and law officer as per the Prison Act of 1894 and the Prison Act of 1900. There is inconsistency in the bail system. Sometimes heavy amount are asked, heavy bond amount. Heavy bond amount is being asked for granting the bail by the magistrate. There is court case pendency. We already saw the pendency in the Court of India. So pendency also, which is result of many reasons, and including the infrastructure of the judiciary. So pendency in the court is also the reason why there is overcrowding in the Indian prisons. Now let us see one more report by the NCRB. As per the NCRB report, the occupation rate of the Indian prison is 108.5 as it has been mentioned here. Of the total prisoners, approximately 69% are the under trials. That means their trial has not been completed and they have not been convicted of their offense. In the case of Arvesh Kumar versus the state of Bihar, the Supreme Court had specifically given two important guidelines. The first was that there should not be any unnecessary arrest for the offense for which less than 7 years of imprisonment is to be granted. The second guideline that the Supreme Court gave in this case was that to give effect to the section 436A of the CRPC, which we had already discussed. Now let us see what are the implications of the overcrowding of the prisons. The first implication is the violation of the human rights under Article 21 and 22, violation of the principle of natural justice, violation of the principle and the safeguards which are set by the United Nations, which is also known as the Nelson Mandela principles. Now let's see the health issues. The first is the mental health issue and the second is the physical health issue. According to the WHO, approximately 17.5% of the Indians, that is 1 in 7 Indian, they suffer from the mental health issue, and the physical health is also important. Now the under trial prisoners, they are deprived of their rights as citizens. Now, according to the Justice Amitav Roy committee, who had recommended some important measures to be taken so as to reform the Indian prison, the first recommendation was the speedy trial, and it also talked about the lawyer to prisoner ratio, which is to be 1 lawyer for 30 prisoners. Special fast track courts for the petty offences, and avoid the frequent and unnecessary adjournments in the court. Plea bargaining should also be there. And for prisoners, the accommodative transition, the legal aid, use of ICT, video conferencing, etc. Admonition and the community service can also be given to the prisoners. Warning can also be given, and they can be fined and they can be released. Now let us talk about the important concept, that is the open prison. Now we know that in order to reform any criminal or in order to reform the society, we must work on the reformative aspect of the society, and therefore the law needs to be reformative and not always punitive. That means it should not always be punishing citizens, it should always also be reforming. Open prison are case in point when it comes to reformative justice. And now let us talk about what is this open prison. In open prison, the prisoners have the liberty to involve in any economic activity, which will not only benefit them but it will also benefit their family. So therefore a prisoner is allowed to walk out of the jail or the prison so as to earn livelihood. However, not all open prisons work on these guidelines. There are different frameworks for the open prison. Some do allow the prisoners to walk out of the jail. Some do allow the economic establishment within the jail premises so as to give them the opportunities to the livelihood. Now let us see how many open prisons are there in India. There are total 63 open prisons in India, and Rajasthan has the maximum number of open prison in India, which is at 29. You can see here, this is the Sanganer open prison, and it is one of the largest open prison in India. And this I have already discussed, that open prison, they works on the reformative theory of the justice. All India Committee on Jail Reform in the year 1980 also had recommended that the open prison can be opened in each district which can be similar to the Sanganer open camp. That means Sanganer open camp can work as a model for other states to work on this reformative justice. The concept is based on the principle of self-discipline. That means a prison is allowed to reform herself or himself. Trust begets trust. If we trust the prisoner will trust the authorities, and that's how the complete reformation process will continue, progress and complete. The reformative process also maintains the human resource. So there is a model prison manual which classifies open prison institution in 3 types. There are semi-open training institutes. For example, if I take the example of Tihar jail, though Tihar jail is not an open prison, but still there are economic establishment inside the Tihar jail, and the inmates can work and sell their product. There are open training institution and open work camps. For example, Sanganer is there. And there are open colonies where the prisoner can live inside the prison premises along with their family. So these are the 3 models on which the open prison work. Now on the United Nations standard minimum rules for the treatment of prison, which is popularly known as the Nelson Mandela rules. Basically, these rules laid down the self-discipline inmates provide the most favorable conditions for the rehabilitation and also for the reformative process. Now, what is the criticism of the open prison? Now, basically, there is open prison per se are not criticized, but what is criticized is that they lack the infrastructure which is needed for the completion of the reformative process. The first is the underutilization of the capacity. The second is the inadequate number of the open prison. The lack of accountability is there. For example, if there is established an open prison, so the authority, the government and the state needs to take the responsibility and accountability for the complete process of reformation, and they also need to take the responsibility, and they should also be in a position to be held accountable for the act done by the prisoner. Applicability: there is no standard when it comes to the application of the open prison. There are outdated laws. For example, the 1900 Prison Act. Now this is a colonial act. India needs to legislate its own law as per the demand of the current scenario. Now let's see what can be done in this regard. We need to follow the reformative approach, and of course the open prison cannot be followed when it comes to the heinous crimes. When it comes to crimes such as rape, when it comes to crimes such as murder, crimes under the POCSO. Alright, so in these type of cases, the open prison policy cannot be followed. However, we still need to reform our prison policy, we still need to reform our prison infrastructure so as to create better opportunity in the society. We need to improve infrastructure, and open prison needs to be explored. This is what we can do. So that's it for today. Thank you very much for watching.